I wanted to bring up this interesting case about breach of fiduciary duty. So we could talk about it a bit.
Oh, what case is it?
It's KUANG against Chiang Wei-Chin, a court of appeal case from 2021.
What happened? What is the story behind it?
About the story, let's check out this documentary I found on Netflix.
Based on a true Malaysian court case, KUANG suing as the father of the deceased, LING against Chiang Wei-Chin practicing as Chiang chambers, advocates and solicitors. It was a quiet evening. LING, the plaintiff's only daughter, had just finished her day and was on her way home.
Hello, miss. Hello. Hi. Okay, where you wanted to go?
KLCC, please.
Alright, let's go. Ish, want to open radio lah, Spotify.
Hey, watch out!
Miss, are you okay, miss? Miss! Oh my god, what happened?
On that tragic day, the plaintiff's daughter was involved in a fatal road accident. Her life was taken too soon, leaving behind a grieving father. Through touting, the plaintiff was introduced to the defendant, a lawyer who promised to assist in a civil suit.
Excuse me, sir. You seems like you have a problem. Is there anything you want to share?
It's glad that you asked me. I recently lost my daughter in a car accident.
I'm so sorry to hear that. Actually, I know a lawyer who is expertise in motor accident claim. So if you want to, maybe I can help you. Maybe I can introduce you to him.
Can you really help me?
Yes, he is very experienced and he is good in his work.
Well, it's really good news for me and for my daughter. I hope this can serve justice to her.
And you can give me the maybe the police report and medical report, and I can pass to the lawyer.
Yes, sure. And ask him to quickly file the case ASAP.
Okay, I will make sure to pass it to him and ask him to file the case.
Okay, thank you.
This is the file for the case.
Oh, alright, thank you. I'm really busy.
The defendant, after being approached through a tout violator, proceeded to file a dependency action on behalf of the plaintiff just before the limitation period to file the claim expired. However, no letter of representation was ever issued. On the 6th of October 2011, the case management was held at the High Court. Neither the plaintiff nor the defendant was present.
It's already 5 p.m. now. This matter was fixed for case management today. No appearance from the solicitor and none of Mr. Agent. No updates on the read, no follow-up file. Client hasn't responded either. As there is no progress on the case, I am striking up with you.
Yes. In late 2016, after years of silence, the plaintiff traveled from Beta Paha to meet the defendant outside her office.
Hi, Ms. Chang. I've been trying to get update on the case. What's going on?
I'm sorry, but your case has been expired, sir.
At least take the document. I'm coming all the way from Batu Pahat.
Okay, fine. Give it to me.
The defendant told the plaintiff that the case was already time-barred. Still hopeful, he handed over the remaining documents. Soon after, the plaintiff consulted a new lawyer.
Hello, can I watch something of my case?
Oh, Mr. Lee, I've checked the court records. Your case was struck off a long time ago because your previous lawyer never attended the hearing.
Oh my god, that's really absurd. I was counting on it. Now, what can we do?
Okay, I'm afraid we need to take legal action against you.
Okay, that sounds like a plan. Let's proceed with that.
However, he went there only to discover the case had been struck off back in 2011. Devastated by this betrayal, the plaintiff filed a suit for professional negligence and breach of contract.
After reviewing the evidence before this court, I found that there was no solicitor client between plaintiff and the defendant. The defendant did not obtain a warrant to act and no legal fees were paid. There is therefore no negligence and no breach of contract. The claim is dismissed.
The High Court ruled that there was no duty of care owed by the defendant, primarily because there was no signed authority or formal engagement between the parties. Dissatisfied with this decision, the plaintiff appealed to the Court of Appeal.
This court finds that even without a single warrant, the defendant assumed responsibility when he filed the suit on the plaintiff's behalf. That alone creates a duty of care. The defendant failed to attend the scheduled case management, made no attempt to contract or update the registrar, did not extract the seal read, and took no steps to transfer the case file to another legal practitioner, constitute a clear breach of duty. The plaintiff, who reasonably believed that the defendant was acting for him, was deprived of the opportunity to pursue the dependency claim for his daughter's death. We are satisfied that the defendant was negligent. We allow the appeal. Damages are to be paid to the plaintiff.
The Court of Appeal found that there was indeed a duty of care between the lawyer and the client, and that duty was breached. The defendant's negligence deprived the plaintiff of his chance to seek compensation, and justice was finally served.
Okay, end of the story. What do you guys think?
That's really sad. The father waited so long just to find out the case was tried out.
At least, in the end, he got justice. That lawyer really failed him.
Alright, so let's break down the legal principle found in the case first. Kishan, want to start?
Sure, Hanan. Now let's address the first legal principle, which is that a solicitor-client relationship can arise by an implied retainer. The solicitor-client relationship doesn't always require a formal documentation, where it can be established through the conduct of the parties involved. To support this, the Federal Court in Gurbachan Singh, Bhagwan Singh, and Velasamy Punusamy case emphasized that the surrounding facts and circumstances could give rise to an implied solicitor-client relationship. Once this relationship is established, all corresponding legal duties and obligations follow, including duties of care, confidentiality, and professional responsibility. Similarly, in the case of Ng Shoi Hui and Asset First Sundran Berhad, Justice Yeo held that an implied retainer existed purely based on the conduct of the parties, even in the absence of any formal or written agreement. Therefore, Hanan, to summarize the first principle, the courts have clearly recognized that a solicitor-client relationship can also arise through a conduct.
Thank you, Kishan. The next principle is that the standard of care of a solicitor towards his client is that of a reasonably competent solicitor. To have a deeper understanding about this principle, we must know a legal test called the Bolam test. The Bolam test is derived from a case called Bolam and Freedom Hospital Management Committee. This case initially was for duty of care as a doctor. However, with the development of the law, the application of this test has been extended to the law industry, which is to be used for solicitors. The test is whether a reasonably prudent lawyer possessing ordinary skill and experience would have acted in the same way as the defendant. Therefore, in the other words, we can say that if a reasonably prudent lawyer will act in the same way when he is in the defendant's position, then it is safe to say that the defendant has met the standard of care towards his client. This test is also applied in Malaysian case Terselim Muhammad Sahal and Co. and Tam Bon Huat, where the claim for negligence failed because the plaintiff did not prove what standard the solicitor was expected to meet. Of course, other than having the same standard of care as a reasonably prudent solicitor, a solicitor must also always follow the relevant guidelines such as Legal Profession Act and Bar Council rulings.
Thank you, Kishan and Caleb. Okay, now let's talk about how a breach of fiduciary duty can occur when a lawyer fails to meet the standard of care. Okay, first, let's look at touting. That when a lawyer improperly solicit client. According to Section 94, Subsection 3, Subsection H of the Legal Profession Act, touting is considered misconduct. To support the provision, the Legal Profession Rules 51 also strictly prohibited it. In the case of Hasina Mira Maidin and Tetuan Razinda, the court highlighted that touting is a serious problem that undermines the integrity of a legal profession. Next, consider what happened when a lawyer is absent from the court. According to Section 94, Subsection 3N of the LPA, it stated that gross disregard for a client interest, like not showing up in a court, is also a misconduct. In the case of Tesali Muhammad Sahal and Tan Boon Huat, the court found a breach of fiduciary duty when a solicitor failed to follow a client instruction. In summary, Rules 51 and also Section 94, Subsection 3H is emphasized that lawyer must not seek client, that client must come to them voluntarily. Any conduct that suggests otherwise is against the professional ethic and the law. Thus, it ensures the integrity and dignity of the lawyer profession are to be maintained. That's all.
So I agree, Kishan, Caleb, and Adilah. This case actually had a big impact on the profession. Don't you guys think so?
Definitely, Hanan. It can really clarify that Malaysian lawyer can be held liable for breach of fiduciary duty and professional negligence even without a formal signed warrant or payment, as long as they have taken responsibility for the client's matter.
Totally. It's like the court said, no fancy sign contract, no payment, doesn't matter. If you start working on the client case, you are responsible. Boom. No escape.
Yeah, it's like an invisible handshake, the famous implied retainer. Once you take action for someone, you owe them your best care. No banking out now.
Invisible handshake, love that. So basically, lawyers can't just say no paperwork, no problem, and run away. Clients get protection even if things are informal.
And the court was super clear about the standard of care. Miss court dates, ghost your clients, that is a big no. You can get sued for that kind of negligence.
Plus, just because the client goes missing in action doesn't mean the lawyer can slack off. Unless the client say, I'm out, you gotta keep the case alive.
Glad lawyers can't just pretend the case disappeared because the client stopped replying. That would be chaos.
Also, ethics start from the very first step. No meeting, no payment, doesn't matter. Once you start working, you have to act honestly and carefully. No shortcut. Lawyers have to be on their A game from the get-go. No hiding behind technicalities or hoping no one notices.
And remember, high standard means high stakes. Mess up, get lazy, and clients can come knocking with lawsuit. So keep those court dates and emails in check, folks.
Yeah, it's like the legal version of don't drop the ball.
And that implied retainer means even if there's no formal contract, if you act for someone, you owe them your best care. No excuse.
This case definitely raises the bar and makes sure clients are not left hanging.
Glad we chat about this, guys. Good to know what's expected, so we don't accidentally trip over this for someday, right?
For sure, it's awesome to see the profession stepping up for client protection.
Yeah, respect to the lawyers doing their job well and make sure their client getting the care they deserve.